We want to welcome you this morning to this meeting of our Drainage District Board of Directors for Hidalgo County for today, April 23rd, 2013. President Dar, Commissioner Cuellar, Precinct 1, Palacios, Precinct 2, and myself, we have a quorum. We have one presenter under open forum, Eva Carranza. Ms. Carranza?
Buenos días, mi nombre es Eva Carranza y vengo de la organización Arise, que es parte de la coalición de Voces Unidas. Hoy estoy aquí porque quiero agradecerles que se hayan estado juntando con nuestras organizaciones, pero aún hay algunos comisionados que no se han podido juntar con nosotros y les pedimos que por favor hagan el tiempo para hacerlo. Sabemos que ya tienen proyecto propuesto para los 15 millones del bono del drenaje. Y solo pedimos que la porción de 3.7 millones que se les asignó a cada uno de ustedes sea usado para proyectos donde las colonias sean beneficiadas. Gracias por permitirnos hacer parte del proceso y tendremos juntas próximamente. Gracias.
Gracias.
Morning, I'm just going to be translating.
All right, thank you.
Today, I am here because I want to thank you for being able to meet with us and the different organizations working in the precincts. There are still some commissioners that haven't been able to gather with us, and we ask that they be able to make the time to meet. We know that you already have some proposed projects to use from the drainage bond, and we ask that the portion that was assigned is used with projects within the colonias that are benefited. Thanks for keeping us updated and allowing us to be part of the process, and we'll see you soon in our next meeting. Thank you.
All right, thank you. Next item is our consent agenda. Any concerns?
No concerns, Judge.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries. Item 4.
Item 4, approval of construction maintenance agreement, CMA, between TxDOT and Hidalgo County Drainage System Number 1 for FM 681 drainage outfall CSJ 0669-01043, et cetera, on the account number. Basically, this is our standard contract that we have with TxDOT when they work with us on outfall projects. This agreement is for us to maintain the system, provide drainage for the area and also for their roadway.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item 5, requesting approval of reconciliation change order number 1 with McAllen Construction, Inc., contract number 1201300410, in connection with the construction of replacement of weir in conjunction with NRCS grant for the main floodwater channel, weir number 2, Willacy County, Phase 2, under emergency declaration approved by the board April 10, 2012. We have the final change order and payment with reconciliation of $316,821.54. So moved. This has been signed off by the engineer and NRCS.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item B, requesting
Now,
approval.
these two projects are not part of the bond issue.
No, sir.
Okay.
Item B, requesting approval of payment number 7 final from McAllen Construction, Inc., contract number 1201300410, in connection with the construction and replacement of weir in conjunction with NRCS grant for the main floodwater channel, weir number 2, Willacy County, Phase 2, under emergency declaration approved by the board on April 10, 2012. Basically, the final payment of that $316,821.54.
Everything took place? Is the invoice and everything in place?
Yes, sir, it's been signed off by the engineer. Everything's been audited out.
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item 6, requesting approval of reconciliation change order number 1 with a decrease in the amount of $71,493.90 with L&G Concrete Construction, Inc., contract number 1201200807, in connection with the installation of rock riprap on weir number 2 in conjunction with NRCS grant for the main floodwater channel replacement of weir number 2, Willacy County, Phase 1. This is the downstream end of the weir where rock riprap had to be placed. We had a reduction in quantities on the project.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item B, requesting approval of payment request number 1 and final for from LNG Concrete Construction, Inc., contract number 12-012-0807, in connection with the installation of rock riprap weir number 2, in conjunction with NRCS grant for the main floodwater channel replacement of weir number 2, Willacy County, Phase 1.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
We do have some items in closed session for the board to
Need
consider.
a motion to proceed to executive session pursuant to 551-071-072.
Check.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries. We'll be in executive session for a short while.
I'll rescind this time, then we're gonna vote on it.
You guys ready? All right, we're back in open session on our drainage district agenda. Mr. Garza?
Under the items under closed session, we'll proceed as directed by the board. I would like for the board, under consideration under item 6B of the regular agenda, for the board to reconsider and take that item back out and allow us to bring it back to you for discussion.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Judge, Commissioner, under item 6B, request approval of payment request number 1 final from LNG Concrete Construction, Inc., contract number 12-012-0807, in connection with the installation of rock riprap on weir number 2 in conjunction with NRCS grant for the main floodwater channel replacement of weir number 2, Willacy County. If the board would take action to rescind this item so I can bring it back for discussion.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Judge, Commissioner, under item 6, request approval of payment request number 1 and final from LNG Concrete Construction, Inc., contract number 12-012-0807, in connection with the installation of rock riprap of weir number 2 in conjunction with NRCS grant for the main floodwater channel replacement of weir number 2, Willacy County, Phase 1. That amount is $71,493.90.
Move for approval.
Second with discussion.
Yes, sir.
The reason you're bringing it back to rescind the action that we took,
Yes, sir.
it's in order to,
In order to read the dollar amount into the records, Commissioner.
And that dollar amount you said was $71,000?
$71,493.90, Judge.
All right.
thank you.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you very much, Judge, Commissioners.
Need a motion to adjourn?
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries. At this time, we'll proceed to our regular meeting. We'd like to welcome everyone to our regular Hidalgo County Commissioners Court meeting for today, April 23rd, 2013. President are Commissioners Cuellar, Precinct 1, Palacios, Precinct 2, and myself. We have a quorum. Please join us in our Pledge of Allegiance. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Heavenly Father, as we observe the National Day of Prayer this week, we recognize that you are the God of all things that are good in this world. Bless our nation with wise leaders who lead with a sense of justice and fairness. Bless our nation with good citizens who are interested in the betterment of our society. Bless us with abundant harvest so that we may continue to help our neighbors around the world. Bless our homes and schools so that they may be refuge of learning and knowledge for our young people. Bless our soldiers at home and overseas so that they may be seen as ambassadors of peace in this troubled world. Finally, Lord, bless us gathered here today that we may do what is best for the people of Hidalgo County. In your name we pray, amen.
Amen.
All right, our consent agenda, any concerns?
Yes, Judge, I would like to ask that consent agenda items 2T, as in Thomas, 11A, 12B, 12E, 12I, and that's in 12I, that's the last one. Be pulled for discussion.
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Judge Commissioners, under item 2T, we're requesting no action.
All right.
Martha Salazar for the Purchasing Department. The first one is,
What about 11A, Sergio? Can you cover 11A also? It's under budget and management. Are you going to cover it, Marty?
no,
On 11A, it's just a point of information. There will be no transfer on the related fringes,
Only salaries?
just for the record, sir. Yes,
All
sir.
right. So I guess you recommend approval, Judge, as restated by budget and management. The approval is only for transfer general fund lab salaries.
That's correct, sir.
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you.
on 12B, Martha Salazar for Purchasing. I'm going to ask that the court proceed to approve this correction. Let me give you some background. We approved this contract on a turnkey solution for some software, some training, and then thereafter maintenance and support on April of 2010. That was the date we marked as the effective date. However, when we sent the company this last notice that we were going to request a 60-day extension so that we can go out for a new term contract for this software license, maintenance, and support, the company responded that when they first received the contract, the initial year, the implementation and the use of the software license for which we purchased a turnkey solution was not effective until September. So what they're telling us is that there's no need for the 60-day grace period extension. It just needs to be corrected to reflect that date in September that it became effective. I sent the situation as the auditor had already expressed a concern. The maintenance and support has already been paid for the year. It would merely be a clerical correction of when this expires. So I do recommend action to approve.
What about the updated insurance document, Marty? Has that been attached or provided?
On the insurance documents, I have nothing reflecting that there is, but we will request it from the vendor.
I'm sorry?
If it's required. I said, we will address it with the vendor.
Okay.
That, our focus was this correction on the date.
All right.
Would that correct the action to be taken?
Legal counsel says that,
As
yeah,
long as the company gave you something in writing that they will
And-
extend the day.
Yes,
then
and I
you're
ran it
okay.
by Ms. Josephine, and she's good with it.
Okay.
She saw no problem. It is merely a clerical correction to state that the license software agreement expires the date they state, and not earlier, which would have been today technically.
Judge, I move that we approve it based on recommendation from the attorney.
All right, those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And just one other note, as far as the insurance is concerned, this is all, they're not on site on the maintenance and support, but we'll get them anyway. So they don't come onto our property. This is a use of a support service and maintenance, plus the license. Going on to the next item that has a concern, it's the 12E. And this is, I'm asking that the court proceed with Welding House. All insurances are current on it, and this is for a 60-day grace period extension. We had to reject the bids that we had opened recently because we had problems with vendors not complying with and accepting our terms and conditions. So we're faced, in order to go out, which we're now doing, so that there's no lapse in service, that we proceed with these two vendors that are currently awarded. Now, SGS has sent us, Welding House is fine to proceed with. SGS has sent us notice when we advised them that we were going out on the 60-day. They sent us back notice that they have somehow been purchased by Alamo Ironworks from San Antonio or have merged with a larger company. We're trying to get that clarified for us, including whose insurance now rules, which it is the acquiring company. I asked that it be approved subject to compliance with those issues, as we're going out for bids anyway, and it's in our best interest to keep these contracts with the 60-day because the pricing's much better than what we had received recently.
Steve,
What about the insurance issue, Marty? Because we have the same thing.
Welding House has their insurances.
Okay.
SGS, we're not sure whose umbrella they're under until we get more notice from them, official word, as to who purchased the company. It's just not clear to us. But it would not be effective on requisitions unless we get these issues resolved.
But right now you have insurance coverage from one of those companies?
Correct.
All right.
And probably under the second one too, under their new parent company, but we just haven't been able to obtain it because this was all news to us very recently, which was the last day or so.
You would
So-
ask legal counsel, Commissioner, a question? Or?
Well, the question is, do you have a current insurance certificate on this company?
On Welding House, there's two vendors.
Okay, so you have it on Welding House. What about the other company?
SGS,
Do you have
Seaguard
a
and Sales.
current insurance certificate on that one?
No, we do not.
Do you
And
know who acquired it?
There is a notice, they were sent to individual departments of the county. It just says that there's some type of merging of several companies because they also give us Industrial Distribution Group and then name about 7 companies that appear to have now been acquired by Industrial Distribution Group. So we're trying to navigate to the actual.
Have you checked with Secretary of State to see what the corporate documents are?
We're trying to do that now, but we found this out yesterday upon SGS calling us. So
I have no problem with Welding House, but until you know more about SGS, I would have trouble with that one.
then no problem. Then I'll ask just at Welding House and no action on SGS, that it be approved that way.
All right.
I need action.
you're
Recommendation to-
recommending no action, you want
I'm
action?
recommending action on one vendor,
Welding
Welding
One,
House,
And no action on the
No
other.
action
and
necessary.
Oh,
no
we're clear
action
on
on
that.
SGS.
Trouble.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
The other consent item is 12I. I'm asking for no action on that one as some funding issues need to be addressed, and I will place it on next week's agenda.
Thank you, ma'am.
Thank you. That's all I
Marty.
have.
All right, in keeping with our policy of accommodating our elected officials, at this time, we're going to go out of order to item number, I believe it's 9A. Mr. Guerra was here. Our district, yes, he's here. Is that the item number, Mr. Guerra? 9A?
Morning, Judge, Commissioners.
Good morning, Judge, Commissioners. I was going to recommend no action on this item based on the fact that, one, it wasn't listed correctly on the agenda, and the other is that Steve Crane had recommended, or his office had recommended that we hold off on it because there's a few changes.
Can you get closer to, please?
I'm sorry, can I?
Sure.
Okay.
Just bump me on.
Yes, what part
There you go.
did you want me to repeat? The whole thing?
No, what Steve Crane recommended. I
He
listed.
recommended that we hold off on the approval of this item for today because there were a few corrections on the, I'm trying to implement an overpayment, underpayment policy for the county. And he looked at it, there's some changes that were made, so I was going to recommend no action for today and bring it back next week.
Do you want to talk about the policy itself, though, without taking action?
Sure.
I mean, that way we don't have to cover it again. Mr.
Basically,
Garrett?
what prompted some of the situations that we have at the office right now is when when you all approved longevity pay, it seems that we have the budget office, we have the auditor's office, we have my office, everybody involved in doing this. When the upload happened from the budget office, it doesn't give me a date. I base everything on a change of status. When I get a change of status, and I think everybody knows what that is the only way that I make any changes to people's salaries.
But is the issue not really what you do or the budget office does, but if
The
there's a
issue was
mistake
the
made,
deduction-
hold on, if there's a mistake made, how do
Yes.
we collect the money back from the employee?
Correct, that's the issue.
Judge,
And according to the auditor, he said that I need to collect in a lump sum whenever it's discovered that there's been an error.
What's wrong about that, or sounds wrong, is that it's not that employee's fault.
That's correct. I agree with that.
And, you know, everybody's got payments every month.
I agree with that, and I also allow the employees, when it's too much, I split it into either 3 or 4 pay periods, so they don't feel it as much. In this particular case, this was one that the department, and it happened to be the district attorney's office, when they were notified, evidently it didn't get to the employee and it didn't get to Mr. Guerra. And so we went ahead and deducted, it was $307, something like that,
How much?
$300. So
Judge,
Yeah.
that prompted for us
Excuse
to
me,
try to
Mr.
implement a
Ocasio.
policy. Go
Did
ahead.
you want
I-
to say something, Mr. Guerra?
Yes, sir. Judge, I first heard about my employee's problem from her after she was complaining that her $300 were deducted out of one check, which caused her to overrun her checking account, and she was not consulted with. And the mistake was made at my office because she had been a part-time employee. Then we gave her a full-time status, and so her longevity was mistakenly started as a part-time employee, which was 1 additional year. And over the many years that she's been with my office, the county overpaid her $300 and something. Now, the auditor, making this a world problem, goes over to the treasurer and says, I want you to deduct that money out of one pay period. And to me, that's wrong for us as the elected official's office, the auditor, the budget office, and the treasurer, all of us were in it together and making that mistake. It started with my office, and now the employee is made to pay back the money in one pay period. I think that's not right, and it just destroys what we are here to do is serve the public. And she does it well. It's not one employee that is going to be changing jobs every 6 months where we may not recoup the money. In the case of mistakes by the county in overpaying, technically, you can't self-help, I don't think. And the proper policy would be to allow some of these employees to pay over several pay periods. Now, in the case of my employee, she's been with me for I don't know how many years. She's got vacation time. She's got sick leave. She's got plenty of opportunities for the county to recoup $300. I mean, we're drowning in a cup of water over $300. Another employee suffers the same thing at the county clerk's office for another $300. And the auditor, with his high hand, goes over and says, Norma, I want you to get that money back because the county cannot give credit. It's not a question of credit. It's a question of a financial mistake that was made by the county, and the poor county employee who's low salary, like I told Mr. Ofracio, we have high salaries, we can afford to pay back thousands of dollars if need be, if a mistake has been made on our salary. But the lower paid employees, it's unfair to recoup that money out of one paycheck.
Norma, do we have anything in place that allows you to make this kind of decision, or?
On the direct deposit agreement that all the employees sign, it does state in there that if there has to be an adjustment to their paycheck, either up or down, they're given as permission by signing that. That's what we have in place. Now, I took it upon myself as the elected official to allow them many times to make it in several pay periods.
Excuse me, I'm talking about
A policy.
a policy. Do
No,
you
sir.
have it?
Yeah, I think
There
that's
may
what
have
we're
been
trying
at
to
one
put in
point.
place.
I'm not aware of it. That's why I was trying to get this thing done, but I want to get it done right. That's why I'm asking
And
for
in
no
the
action.
past, how do you handle similar situations?
Usually, when it's happened in the past, we have an agreement signed by the employee that they agreed for us to deduct for so many pay periods. That's the way we've handled it, but
Is that legal? Is that fair? I
Well-
mean, fair, I think it's
according to the auditor, he tells me that I'm not a loan company and I can't be
I'm not
doing
an
that.
attorney, but I'm going back, is that the practice? I know we don't have a policy.
Yes,
Why don't we hear
that's
from
been
the
the
auditor?
practice.
Why do you think we need to?
Can you please allow me to correct something, Judge?
Sir, yes, it's what I'm calling on.
First of all, I have never instructed the treasurer to take the money out of one paycheck. Mr. Guerra is wrong in saying that I asked him to do that. I simply sent her a letter saying that there appears to be a mistake on the payroll records, and for them to research and find out if the money is owed, and if the money is owed, to ask back from the money. Those are county funds that by law you should not be giving them to anyone. If there was an error made, it needs to be corrected, one way or the other. Either
Right.
underpaid or overpaid, it needs to be corrected. Now, Treasurer in the past has made arrangements for employees to pay it in payments. And what I had told her was that she has no authority to approve that she has to come before Commissioner's Court for that approval, in my opinion. Because she's an elected official, but yet she's a steward of county funds, that the county commissioner is responsible for making sure that monies are paid out correctly.
So she has to come back for your approval?
No, for the Commissioner's Court. What I had told her was go before court and get approval for court to have an easy payment plan, not take it upon yourself to do that, in my opinion. But
Steve,
that's what all I had said. I had never instructed her to take it out in once and to not notify the employee. She's
No,
done
no,
that in
no,
the
I
past.
did not say that you said not to
Gentleman said-
contact the
no, gentleman
employee.
said that. That's what
That's
I'm
not what I
saying. I'm
said.
correcting him.
No, sir.
So you, Mr. Ufracia, you see nothing wrong with working out some kind of a reasonable
No,
payment
there's-
plan?
There's nothing wrong, but it has to be approved by the governing body, not by an elected official, in my opinion.
Why don't you work it out with the
Which is
employee,
why-
whatever he or she
exactly.
believes is fair, and then just put it on consent or bring it back to us and we'll
Okay.
approve it?
Judge, let me make another comment. What happened when court approved this longevity policy back in 2006,
Eight.
7, 8,
8,
a file was uploaded into the payroll system that had incorrect dates. So we're discovering now from time to time this error. So what I recommended for the budget office, since they were involved in the uploading, is to do a research and find out how many other errors we have. Apparently, we have more than one, and they're coming up on a regular basis now.
there's
So they
about
need-
200 employees
Yeah,
that,
there needs to be a review, and there needs to be a correction made on all those employees. Those are county funds that were paid out in error, and they need to be returned back to the county.
and most of the departments are told that they need to submit a change of status for us to be able to change it in payroll.
well, I would agree with.
That's
the-
why I want the policy,
Norma,
Commissioner.
I would agree with the judge, go back with the employee, work out a plan with them. And when you present
Okay.
the item again for
So we can
action.
approve it.
Yeah.
Right, something that's fair for the.
Okay, in this case, the money has already been deducted from the employee's account. Actually, we have 2 cases.
We'll
Am
give
I
it back
supposed to
them.
return the money to them?
Well,
Yeah, I mean, that's their money. It's their
No.
the
He's saying no because it's the
It's not their
county's
money, Judge,
money.
it's the county money.
Because then you compound the problem even worse.
See, the problem exists because that employee has to make payments. They got car payments, house payments, light payments, water payments,
I understand the problem. What I'm saying is, I don't think you have any legal basis to return that money.
well, I beg to differ, and I'm not an attorney, Chief, but the practice has been that we have done this over time with other employees. Now, so that take precedent over the policy or lack of a policy?
During the course of these past 10 years that I've been doing it, because of the authorization on the direct deposit is the one that we've hung our hat on,
The fair thing to
basically.
do is give the money back, sit down with them, work out a payment plan, and bring that payment plan back to us.
Judge,
Now-
I don't think legally you can give money that doesn't belong to the employees.
Well, we didn't legally take it.
Yes, sir. Money belonged to you, so you took it from them because you paid it in error. You should have made arrangements, but you didn't.
Judge, I don't know of any case decided in any court that says that this is the way you do it when an employee has been overpaid $300 or $400 or $500. A county employee has been with the county, working for the county faithfully, and we as elected officials and other higher-ups made a mistake, either in a typo or a wrong entry into a status form, that we should all be reviewing carefully. Now, these mistakes are not just Norma's, they're also the auditors. Why didn't he catch them back then? And now I think that he even, when we hire a new employee, he has to approve the new employee, and he's undertaking some duties that I don't think belong to him in the approval of hirings. Now, a simple policy says, let Norma, the treasurer, work out a contract where the employee will pay back a mere pittance. And not talking about something that would require county commissioner's action every time there's a one penny overpayment. For Christ's sake, let's do it the right way. And let Norma, the elected official, the treasurer, to work out an agreement. And by the way, I didn't learn about my employee till she told me that, she called me, that this had been done to her, and on that same day, she had a wreck. And she was really upset at the way the auditor had handled the situation. Now, if he did it, if he walked over to Norma's office to have the money withdrawn, I don't know. The thing is that this payment was made to her without her approval, without her knowing, as far as I know, right? She didn't even know. And so when my check is low for several $100s, and I'm just living from one paycheck to the next, what do you think is going to happen to checks that are authored thinking that the money's in the bank? It's not fair, and I think the auditor has the discretion, and all of us have the discretion to work with that employee. It's not a question of thousands of dollars like we have in some other situations. So that's all I have to say on the matter.
Yeah.
May I be excused?
Well, we need to address that employee's problem, and I don't know how the court feels, but I think that's a fair thing to do, is to simply cut them a check for what they earned on their salary that we had taken. I want to say that inadvertently, and then let our treasurer work out a payment plan to get it repaid back.
Understand that before I can issue a check to that employee or those two employees.
Well, I mean, she needs it or he needs it.
The auditor needs to okay it, because if he doesn't, I cannot cut a check. And just like he can't cut a check if I don't okay it.
What do you see as legally incorrect about that, Mr. Ocasio? Everything is out in the open. We know that the county is due $300, and we're working out a payment plan, a repayment plan.
Here's the issue that I have, Judge, that money is not owed to the employee. The
Well,
employee.
she earned it or he earned it. He worked for those 2 weeks.
The employee was paid $300 in error. So the treasurer took it away from her paycheck.
But it was not their error, it was your error,
I
the
understand.
treasurer's error, the budget department's error. I
The
mean,
DA's error, it's everybody's error, but bottom line, we paid the employee more money than we should have had paid. And the statute that I always cite is not so much the credit, is the statute says that you cannot give anything of value, you cannot give money away.
and we're not suggesting that they grab a windfall. They're going to pay it back, but they want to pay it back within, in a reasonable terms.
But she already paid it back, Judge. So
No, she
we're
didn't
even.
pay it back, we grabbed it. That's a difference.
Right, but she gave authority to the treasurer to do that, and she did. So now we're even. I don't think you want to create the problem again, to give the money
Well, it's
back to the
not, the
person.
problem is I'm trying to address that employee's problem, not the county's problem.
What action do we need to take in order for you to approve the release of the check?
There's no action needed because, again, we paid the money in error, we recover it, now we're done.
Excuse me, the judge is making a recommendation. I concur with his recommendation to instruct Norma to issue a check and then work on a payment plan. What does it take to get you to release or approve it?
Your legal counsel saying that you're compounding the problem by doing that. So again, I'm going by your legal counsel's advice.
Judge, Mrs. Muniz from the county clerk's office, her department was affected as well. It was one of her employees, right?
Right.
Can she address you?
Yes.
The only one thing that I wanted to say is that auditor keeps saying about these $300 that was given to the employee. It wasn't just given to the employee. In 2007, when the longevity was approved, It was going to be for employees that had worked over 5 years, and as Mr. Guerra explained, some of them got caught with, they were not, they didn't qualify quite yet at the 2008. On 2008, our employee, like the other employees, got paid an additional year at $11 per paycheck. Nobody gave them just $300 and handed it out. But this was in 2008, and it wasn't discovered until just now, March of 2013. And to just take it out just like that from the employee, that's what's unfair. I mean, they didn't just accrue it at one time, so they should at least be considered to pay it back in small amounts.
So we already have a policy unwritten in place where we've done the same thing before that we're suggesting. When it was repaid in small increments.
Well, no, because Mr. Ufracio wants it paid, or my understanding.
No, back when you did it and your employee.
No. When the employee was receiving that error, they were receiving $11 per paycheck.
But how did they repay it back?
They haven't paid it back.
Oh.
Well, we haven't, because we looked into the law, we looked into the way that it was being done, and that's when we questioned there being a county policy.
So they haven't deducted that from your employee?
Well, I think we just need to authorize our treasurer to work out a policy, a reasonable repayment plan, and put that employee, the one that we went in and inadvertently or knowingly or willfully took that money out of their bank account, because that's what we did. You automatically deposited,
Yes,
and then you went out there and took it out
basically, yes.
without her consent or his
Well,
consent.
that's where I differ with what's being said. There was a letter from the auditor to us, there was a letter from budget to the DA's office to tell the employee that this was going to happen. Normally, we rely on the supervisor or the department head or the elected official to notify them. We also go a step further most of the time, like I was telling Annette the other day, 9 times out of 10, we actually call the employee to tell them this is going to happen. This one, they didn't call. That was my mistake, my office's mistake. So I think that next week, if we come with a policy, it should address this and take care of it for the future. What we wanted to know right now was what to do with the one that was already deducted.
Well, the auditor says it's all.
Then it's fine.
We can work out a repayment plan, a reasonable one, if our lawyer says it's legal, I guess.
He's already looked at the forms that I had submitted.
Oh, so we can do it?
We're in the process.
But I'm talking about the 300. Can he
Oh.
legally give it back?
Bring it back next week.
You know, put it-
Legally, I'm being told no. Go ahead.
I don't believe we can award the money back to that employee. The fact that we already recouped the money from the employee, I don't think at this point we can go back and give it back to the employee and create a duplicate error.
But
It's unfortunate.
Sergio, but they need money for.
The only thing I can think of, Judge, would be to, and again, I'm not sure whether if we amend the longevity policy at this point, whether it would be retroactive to this last instance, or it would only be moving forward. Yeah, it would be only moving forward. So again, it wouldn't address this instance, but it would address any future instances. Our office will start to undertake the review of these, so we'll hopefully
Well, we're
prevent
spending
this.
too much time on this matter, the way I see it. Steve, is there any way that we can legally be able to give that employee back the money that they had earned for the 2-week period of time?
It would have to be for additional services that employee performed for the county.
Well, we don't want that. They're going to be entitled to payment again for those services.
Unless it was a short-term project.
Why don't you,
There's nothing on the agenda to take the action we want.
why don't we do it next week then? Put it back and Steve, work out something, man. You've got to be
That's why I
able
had
to work
recommended
out.
no action from the beginning,
Sure.
to clear up all these things.
All right.
Okay?
We're going to
Thank-
try to figure out a way, tell that employee that we could give him or
All
her
right.
back that $300, and you sit down with him or her, and by next week, come up with a repayment.
Okay, thank you.
Okay, by the way, today is Ms. Muniz's birthday.
Congratulations. The auditor's making an offer. I don't know, $30 out of $300.
We go back to item number 5, open forum. First presenter is Beth Barnes.
Morning, Judge and Commissioners. I've got a little invite here. I know it's coming a little late, but it is how we can maybe protect our schools. This is called the Paper Fortress, a reality behind public school security. On Wednesday and Thursday, the 24th and 25th of April, at the Church of the King on North Ware Road, the Tea Party is presenting Mr. David Thweet from the Herald ISD, Texas. He's the superintendent. He addresses one of the most pressing needs of our public schools in America, preventing our children from copycat school shootings. Many believe that we can prevent shootings by simply locking doors or creating and practicing elaborate emergency drills. He believes that these are procedures, while necessary and appropriate, fall short of solving the problem and give false hope to those who believe in their effectiveness. He's in the limelight in August of 2008. He managed to effectively defend his school employees' concealed handgun policy. When the issue resurfaced after the Newtown, Connecticut school shootings, Herald ISD's Guardian Plan, implemented in October of 2007, was praised as common sense approach to protecting America's school children. He's going to present and argue for one of the most novel paradigm shifts in recent educational security philosophy and explain his district's solution and present the reasoning behind it. This is all to keep our children safe. It's not a cure-all, but he has worked it since 2008, and it has worked for him. We are putting this invitation out to you and all the public that is here today to just attend and hear what he has to say. So that is the 24th and 25th of this week at 6:30, a meet and greet. 7 o'clock, he'll be giving his presentation with questions and answers. Thank you.
All right, thank you. Next presenter is Fern McClarty.
Good morning. My
Morning, ma'am.
question this morning is on, I guess it's number 7, E, F, and G. We have the purchasing department that's going to attend a conference in San Antonio for 3 days, and our question is, purchasing department does pretty good every time we look on the agenda at buying things, but we're just questioning why 2 people need to go. Fire marshal, he's going to go to Florida, and then the safety division is sending 2 people to a conference up there. Our question is, if we need to spend this for these conferences, why does it take 2 people to go to these places? And I know that each week y'all talk about the new courthouse and the bond issues and everything that we've got, and I know that I'm trying to keep taxpayers' taxes down each year. I heard through the grapevines that STC one time, the one that says just need a little bit of help, is coming back for a big help. They're going to come back for a $150 million bond. It's never ending between each one of the entities that you put on and allow to come on our taxing bills. It's constant. They need more buildings. They need more something. And again, we're just asking to see if you can't look at the taxpayer that's paying all the bills for all the different entities, and it's never ending. When you go to jail or to prison, you do your time and then you get out. Taxpayer never gets out, and y'all keep burdening them each time that y'all spend the money. Thank you.
Next presenter is Elda Gonzalez.
Buenos días, señor juez, comisionados y demás personas presentes. Mi nombre es Elda González. Soy miembro de LUPE y soy residente de la colonia Taurus 14 al norte de la ciudad de Mission y pertenecemos al precinto 3. En el año 2005, miembros de la Unión del Pueblo Entero comenzaron a organizarse sobre el asunto de la luz pública en colonias, debido a que la falta de dicha luz les causaba inseguridad y peligro para miles de niños y familias que vivían allí. Se procedió a trabajar con la entonces representante estatal Verónica González en una propuesta legislativa que le daría la habilidad al condado para instalar alumbrado público en las colonias. En el 2007 se logró que dicha propuesta pasara a ser una ley. Sin embargo, esta ley estatal no permite que impuestos sean usados para infraestructura de alumbrado, pero lo que sí permite es que el condado pueda contratar una compañía pública o privada para colectar costos de electricidad de los residentes en colonias. Hemos visto ya la instalación de luces solares en algunas colonias en 3 precintos de nuestro condado con el uso de fondos del CDBG, pero debido a que estas lámparas son de alto costo, los fondos destinados para ello solo alcanzan a cubrir una mínima parte, ya que todavía seguimos con 1,000 colonias sin alumbrado público, quedando estas colonias en oscuridad y en mucha inseguridad. Nosotros creemos que si se invierte parte de los fondos del CDBG en lámparas regulares o mercuriales en lugar de las solares, porque son un poquito deficientes y muy costosas, el dinero puede llegar a impactar a muchas más colonias, y si unimos esfuerzos con proveedores de electricidad que puedan encargarse de colecciones y mantenimiento. Nuestra organización Lupe, junto con Arise, Top y Start, estamos organizando una campaña de alumbrado para informar a la comunidad que ignora esta situación sobre inseguridad y consecuencias de alto costo que resultan por la falta de la luz pública en nuestras colonias. Estamos comenzando esta conversación con la comunidad para mejorar la rapidez y eficiencia de la luz en las colonias, y para ello estamos contactando aliados como miembros de iglesias, negocios, organizaciones locales y policías también locales que nos están apoyando. Queremos que el condado tome este asunto con seriedad y que se incluya en conversaciones con proveedores de electricidad para que ellos se encarguen de colecciones y así se puedan instalar luces regulares en las colonias. Y estamos pidiendo la ayuda de todo el condado para poder alumbrar estas colonias en un periodo aproximado de 10 años. Las consecuencias de no tener alumbrado público son muchas, como para que estén siendo ignoradas. Muchas gracias. Gracias por su atención.
I was asked to translate, but I probably won't translate that word by word. We at Lupe with Top and Start and Arise, some community-based organizations, we've been working on the issue of public light from the very beginning with Representative Veronica Gonzalez, who's been here a few times, and we awarded her on her passage of the bill, a state bill in 2007 that allowed for the county to be able to put public lights in colonias, which we've been putting up solar lights in colonias. However, we have studied the bill, we looked at the bill, and we know that you cannot use taxpayer money to put public lights in colonias. That's very well understood, but what could happen is that Hidalgo County could work in collaboration with electrical providers like Magic Valley or AP in order to actually collect fees from colonial residents in order to put the public lights up. And I think that's really the conversation that we want to have here, is for the county and the electrical providers and the nonprofit organizations here, is to have that conversation, re-engage that conversation that didn't happen years ago, because the state law passed 6 years ago, and we really want to see what we can happen. We know that there's been CDBG funds that have been invested in colonias for solar lighting. We do trust that if we could get Magic Valley, people like Magic Valley or AEP on board, that we could probably get a lot more lights up with regular street lights instead of solar lights that are very expensive. So I think that's the gist of the message here. Thank you.
Next presenter is Mr. Frank Travers.
Good morning, Judge and Commissioners. Just a short remark or two this morning. Virginia Townsend could not be here due to some pressing family business. If she were, I'm sure she would have had a remark or two about your late start this morning. If I can pinch hit for her, I can't be nearly as eloquent, but we just wanted to remind you, because Virginia couldn't be here, is no excuse to backslide or depart from your most recent excellent record of punctuality. Thank you very much.
Next presenter is Opal Billman.
Just a comment, Judge.
Our next presenter is Commissioner Tito Palacios.
I appreciate comments, but if it intended to be directed at one or several of the court members, I would appreciate it if you would indicate who they are, because I think my track record has been that I have been on time, ahead of time, waiting, and this for clarification purposes. I am here always on time and ready to go, and not take anything away from anybody. But just to clear the air. Thank you.
All right, next presenter is Opal Billman.
Good morning. My name is Opal Billman. I am not a lawyer. I did not go to law school, pass the bar, open a law office, and start practicing law. Joe petitioned the 275th District Court for a divorce 17 years ago. The court is a location where officials of the government practice existing law. Existing law because whether federal government or state government, to become an existing law, bills must be submitted and passed. Officials of the court do not get to make up their own laws. The foundation of their judgments is supposed to be based on existing law. In this country, we have existing laws that are rational, fair, and just. The community property of Joe and me is 72 acres of land with capital improvements. There was no real estate appraisal of our land and capital improvements, and there was no division of our community property. Because nothing was done regarding a settlement of our community property between Joe and me, we still own it. Division of our debt-free community property would have been simple. Acquire a survey, draw a line through it. Instead, the judge divided $650,000 and gave Joe and I a 15-year use of our own property to earn the money. The division of non-existent money in lieu of a settlement of our community property is bait and switch fraud. Our community property, the judge awarded in an owality deed of trust to his appointed beneficiary. A beneficiary is the person who benefits when someone dies. The owality deed of trust documents that the beneficiary paid Joe $10 for all of our community property. When real estate is sold, a monetary sum must appear on the deed. It does not have to be the actual amount. It is just there to be proof that the land was bought and sold. Being community property, our land must be sold by Joe and me. Joe did not sell any of our land, and the beneficiary did not buy any of our land. That's just hogwash. When Joe died, the law is this case must be dismissed, which means the owality deed of trust must be lawfully vacated. I do not believe the judge has the law to appoint a beneficiary for our community property and call it a divorce settlement. I do not believe the law allows community property to be bought and sold while in litigation. Since the judge has not closed this case by dismissing it, there is no existing law being applied to the case. In 2008, I believe the case to have been dismissed, and after getting an okay from the Mission City manager, I went to my rec hall. In 2009, I was tried and found not guilty of criminal trespass. In 2011, because I believe the case was dismissed, I walked over to my rec hall for the weekly activity of coffee and donuts. I was arrested in 2012,
tried, and found not guilty again. I cannot trespass on land that I own. These trials were for the purpose of the one law the court wants to follow. 3 strikes and you're out. This effort is to oust me from my home with a 3rd trial. I hold valid deeds to this property in my name, purchased in different parcels throughout many years. Deeds where we borrowed money from Wayne McClure at the First National Bank to buy one of the parcels. Deeds where Bill Patterson, an attorney in McAllen, handled the paperwork for another parcel. Deeds where Willis and Mildred Billman bought the north 20 acres of John H. Sherry in 1942. Deeds for conveyance between family members. The judge determined all of these parcels of land to be excess land with no value. The land has value to the owners. We invested money in the land and paid taxes on it for many years, and still do. I am being held in police-enforced false imprisonment with a 3rd trial being held over my head, all for a divorce between Joe and me? Not hardly. It's for 72 acres of land with capital improvements. I do not practice law, but the officials participating in this police-enforced Donnybrook for the purpose of taking community property away from the rightful owners for a payment of nothing are not either. Thank you very much for your time.
Is Josie here? Can you make sure that Victor gives us that memorandum on open forum? All right, item 6A.
Good morning, Judge. Good morning, Commissioners. My report, Rick Alvarez from the County Judge's Office. My report is on bills before the Texas Legislature of interest to Hidalgo. Just to note, Judge, today marks the 105th day of the 83rd legislative session. There's 2 things that we're going to bring up today. The weekly report for the week of April the 15th to the 19th, and House Bill 611, which will be a presentation by Raul Cecin. Let me start off with Senate Bill 1426 by Hinojosa relating to the appointment of county auditors. That's in the Intergovernmental Relations Committee, and the action on it is scheduled for public hearing on 4/24/2013. SJR 1 by Williams proposing a constitutional amendment providing for the creation and use of funds in state treasury to provide financial assistance for certain projects related to economic development and water infrastructure, and for transfer of funds of the money from the Economic Stabilization Fund, also known as the Rainy Day Fund. That's in the Finance Committee. It was placed on the 10 calendars. Senate Bill 170 by West relating to building code standards for new residential constructions in the unincorporated area of a county. That is in the Intergovernmental Relations Committee, and it was reported favorably as substituted, and it's going to be placed on calendars.
What kind of construction? I think, Mr. Alvarez, if you would, in your presentation, give us a little bit more information as to the impact or the effect of these bills. For example, that one is a good one, SB 170, but it's very difficult to understand what it's going to do unless we're told.
I'll give you more information on the Judge.
All right. And does any member of the court have any question on any of these bills?
Rick, I think 1426 being taken off the schedule.
I checked it yesterday, Mr. Auditor, and that's what was on the schedule.
This morning, it's no longer there.
Okay. We'll check it again.
All right, thank you, sir.
Yes.
Raul, are you going to make a statement or something?
If I may, just real quick. Judge, Commissioners, good morning. Raul Cecin, Planning Administrator. We've been monitoring House Bill 611 by Guillen, and this is one that I reported a while back regarding some changes to 232, which is our main enforcement chapter that we have for colonias. As of this morning, it's my understanding that one of the issues that we had on there was the earnest money contract that they want to try to collect money. So it's my understanding this morning that they pulled that out of the bill. Another issue that we raised was the 90-day cure affording the opportunity for, I guess, the developer if, to have 90 days to receive a notice before enforcement action can be taken by the AG unless it's a health and safety issue. And we still had a concern with that. So right now it's at 45 days. They're still discussing it. My understanding is going to be on the House floor this morning. So they're still somewhat discussing it with our Valley delegation and with Mr. Guillen as well, who's, I guess, our neighboring county representative. And we're looking at this bill, still monitoring to see which way it's going to go. I think it's good that Earth's money contract issue was addressed. I think it would kind of cloud the issues that we have now and may put us back to where we were before of exchanging of money and not, miscommunicating to our clientele that we serve. And then the enforcement or the time to cure, we had thought possibly a 30-day and make it administrative also, to add the word administrative in there. And they're working on that as well to see if they can put the word administrative in there. But that's where we are on that bill right now. So we've been in contact with the state reps. Mr. Osuna, Jesse Osuna from Commissioner Precinct 4's office has been very helpful in establishing communication with our local state reps up there. So we've been working through him a lot and keeping that communication open to try to keep monitoring this bill and see which way it goes. But those are the two main issues that affects our county. And one of them has been addressed. The other one, we're trying to see if we can put the administrative word in there and apply it only to administrative errors on a subdivision plat, and maybe give them a 30-day time to, once it's found that there's an error, give a 30-day time to fix it before a suit is filed by the AG or the DA or the county attorney, or actually, I guess DA or the AG would apply. And the reason we're opposed to that is because I don't know of a case now that the AG doesn't discuss with the developer problems with the plat or any issues that have come up before filing on them. Traditionally, they have open communication with the developer and try to bring it into compliance, and then when they refuse, then I guess the last remedy is to file suit and bring it in compliance. But that's where we are on that.
Thank you, sir.
Yes, sir. Thank you.
I want to make everybody aware that we got 1 hour and 15 minutes to finish our meeting. The city is going to be needing this facility, so we're going to try to move it on as quickly as possible. Under item 6B.
Good morning, Judge, Commissioners. Karina with the Public Affairs Division. Item 6B is a proclamation declaring May 2nd, 2013 as National Day of Prayer in Hidalgo County. The National Day of Prayer is an annual day of observance held on the first Thursday of May, designated by the U.S. Congress when people are asked to turn to God in prayer and meditation. And I would like to introduce Mr. Adrian Esparza, who is heading up the efforts this year to have the National Day of Prayer events at Hidalgo County outside the courthouse. Mr. Esparza, would you like to say a few words?
Judge, Commissioners, thank you. I just want to thank you all again. Year to year, I realize the privilege and of course, being able to do it there in front of the courthouse and being able to shut the street down and all that goes on. I just want to thank you.
Yes.
Oh, yes. I was going to try to keep it quick as what you just said, but some of the details are going to be it's going to be on May the 2nd from 8 in the morning to 8 at night. We will be having a full schedule of different mayors and of course our judge and doing their proclamations. We have several churches involved, just several different people that will be coming in prayer, and we have worship bands. We have about 5 bands, and we have just different groups throughout the day. So I do encourage you all to make it if you can.
Thank you, sir.
Thank you.
So we have a proclamation if you would like to just move for approval, or you would like me to read it?
So move.
Those in favor indicate by saying aye.
Aye.
Aye. Motion carries unanimously.
Thank you, and if you don't mind taking a quick picture.
Thank you. Item 7, Mr. Guerra. Oh,
I think they were going
yeah.
to take a quick picture, Judge.
How you doing, Amy? Okay, Mr. Guerra, let's
Thank you,
move on.
Judge. Thank you, Judge Commissioners. Item 7A, 1 and 2, no action. Item 7B, 1, 2, 3, no action. Item 7C, I am recommending approval of Mr. De Los Santos and 2 staff members from the Veterans Office to travel to San Antonio for the Texas Veterans Commission 2013 Spring Conference in May.
Move for approval.
Second.
You might want to know that the Texas Veterans Commission is going to pay for the lodging.
Yes, and the food expenses. Yes, sir.
Those in favor indicate by saying aye. Aye. Aye, motion carries.
Item D, I am
Judge,
also...
if I may,
Hold on.
Yes, sir.
Malte, I'd like to recommend that this travel requests that come in be handled to the consent agenda. I think it's a responsibility of the department head, or your responsibility in supervising the department head, and that should be part of the evaluation in terms of managing the budget.
Commissioner,
I know we have a policy.
Well, it's I think it's an unwritten policy, but I do agree if the court is in agreement, then I will evaluate the requests and I will take care of them administratively.
I think if you can handle that through the consent agenda, and
Okay.
it would expedite matters.
Surely will, Commissioner. Then if I may, item 7D for the extension service, I am requesting approval for them to travel, for Ms. Barbara Stores to travel to Galveston, and this is for professional development seminar and program conference for the extension service.
So moved.
Second.
Those in favor say aye.
Aye.
Aye, motion carries.
The second part, I'm also asking for Barbara Stores, Brad Cowan, Adelita Munoz, and Cristina Perez to travel to South Padre Island. This is for the District 12 Spring Facility meeting, again, for the extension service.
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
But
Aye, motion carries.
these are not county employees, so
But
my assumption is that
they're using county funds. They're using county funds.
Okay, thank you.
That's why. But I will facilitate as the court has directed. Item E, Purchasing Department, I am also asking, and I have looked at the travel, I'm asking for Darlene Betancourt and Leticia Saenz to attend the Lone Star Conference for Public Purchasing Association in San Antonio.
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
As well as for the Fire Marshal, I am also asking for Wes Bradley, our Chief Deputy at the Fire Marshal's Office, to attend a training conference, the 2013 IAAI Annual Training Conference in Orlando, Florida, for May.
So moved.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item G, I am also as well requesting permission. I have looked at the travel, and I am endorsing the travel for Mr. Armando Guzman and Rene Parao to attend the OSHA 50290 Update for Construction Industry Outreach Trainers. This will be held in San Antonio in June.
Move for approval.
Check.
Those in favor say aye.
Aye.
Aye, motion carries.
Thank you, Judge Commissioners.
Item 8, Constable Precinct 1.
Good morning, gentlemen. Requesting approval to process payment for the following invoices, claims to Slick Fit Wash and Lube with authority for the county treasurer to issue payment after review, audit, and processing procedures are completed by the county auditor.
Move for approval.
Second, can you read the amount?
Do you have an amount, sir?
I don't have the amount here.
All right. There's been a motion and a second. Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you, Jim.
Item 10, our Health Department.
Yeah, I was gonna look it up too.
Good morning, Judge Commissioners. Item 10A, discussion and action on Cleveland Unlimited Energy and Healthcare Program 1115 waiver. There is no discussion unless there's a questions or comment from the Commissioners Court.
No action?
None, sir.
No. Item 10B, presentation regarding more health at UT Pan American Conference. There's on April 25th through the 27th, this Thursday, Friday, Saturday. University of Texas Pan American, along with the Hidalgo County Health and Human Services, sponsoring their first annual Maximizing Opportunities of Research and Education for Health conference, and it's going to deal with obesity and diabetes issues in our community. We have the Commissioner of Health, Assistant Surgeon General, several national dignitaries coming in and presenting at this conference. It's sponsored by the university. I'd like to invite anyone and each and every one of you to, if you have a chance, participate and take part in it. And it's going to have several activities involving community education and awareness. It's Thursday, Friday, and Saturday of this week, just for your information. No action is necessary. I'll proceed to item C, requesting approval to process the following AT&T invoice as claims with the authority for county treasurer to issue check after auditing procedures are completed as indicated on agenda, totaling the amount of $4,926.
Move for approval.
Mr.
Check.
Discussion?
When are we going to have this telephone lines added to the DRR contract?
We have submitted all those lines to be added, sir. I know that Renan, the IT department, budget office, and purchasing are all working on coordinating efforts with AT&T and the various vendors. I know it's at their level, sir. I would have to go to them and ask them where that's
I think it
at.
would be a good idea to ask purchasing department, just because these invoices are being placed as a claim every week.
Yes, sir.
And they need to be added to the contract to avoid this issue.
My understanding, sir, is that all the efforts have been done by the county. I think that we're just waiting for a response from AT&T and Verizon, I think, are the other vendors, sir.
But Eddie,
yes, sir.
beyond the fact that we're paying modest claims, I received some information that we were paying about 8 to 10 times more
Correct,
than the
sir.
contract claims. So we're overpaying simply because we don't have a contract on these particular issues.
A
And we
DIR
authorized,
contract. And it's not only our department,
but
sir,
did
it's
we authorize,
several other departments.
Mr. Ramirez or someone to enter into this agreement?
Marty, can you?
We've commenced the transfer over to the DIR. What occurred
You better
was-
repeat it again. You were talking
I'm sorry.
and walking. I didn't hear.
We have commenced migrating all of these over to the DIR. On the Verizon, what is happening is that Verizon has a floating rate. They don't have a contract with the state.
It's our AT&T,
And-
Marty, right?
Yes, AT&T is the DIR.
Right.
And-
See, but the
and-
thing is that.
No, but I'm saying they're coming up as a double problem.
Right.
These are being transferred over to DIR, but these were bills that were prior to that transfer.
What
so
is
they become-
DIR?
Department of Information Resources for the state of Texas.
No, these are current, these are month to month.
And the
But yeah,
county.
These are on month to month, and they're all AT&T,
Well,
correct?
my concern is, since when do we know that we're paying
We have several.
3 or 4 times a month?
8 to 10 times.
Let
is
me,
what I was
let me look into one thing. We had at about a month or even a little bit longer.
Marty, the question that I had was, since when do we know that we're paying more than the contract price?
Since about January. But remember, Commissioner, this all began when it was asked of the county to start to start issuing purchase orders on what we considered a utility. At that point, now on the AT&T, they were awarded the DIR last year, but could not migrate over. AT&T and DIR were in negotiations and in the final stages of changing over. Not
Whose
all,
responsibility, Marty, is it at the county level to enter into this agreement with AT&T and?
but the agreement with AT&T now is under a DIR contract.
The thing is both the IT
We brought a
department and
list
purchasing judge.
about 6
Wow.
weeks ago of a lot of numbers that were already transferred
How do
over.
we stop paying 8 to 10 times more than we should be?
That's what I'm trying to tell you.
All right,
We've already
I'll listen.
started to do that. However, I'm going to go back and double check that about 2 months ago, we brought an extensive list to court to migrate over to the DIR. I need to cross-reference them and see if those were also included. That's when we were doing our research on how many lines did we have that we needed to migrate over.
My understanding, all those lines have migrated over. The only thing is what I understand is that the only thing we're waiting to hear response back is from AT&T accepting it. That's what my understanding is, and Verizon working some kind of deal out with the county.
Why don't you put it on the agenda for next week and report back to us if we solve the issue?
Yes, these bills have to be,
Well, I think the intent of the court is to not pay more than we should.
oh, certainly, and it's our intent also. I'm going to cross-reference those numbers that had already migrated over to this AT&T, and I'll have a report to you next week. However, these are existing bills that need to be paid.
Judge,
But I will
think-
give you a full report on how many numbers we've been able to migrate
You
over.
need to be on top of that with department heads.
Yes, sir.
I'll have a report for you.
Judge, so you want us to pay only the contract amount? Because, again, court already approved the inclusion of these accounts into the DRR
We'll
contract.
receive some type of payment, it becomes a dispute.
Yeah, we owe it, but Judge saying that we're paying like 8, 10 times
At the
more.
rate that we pay, what need to be looked at.
Is it,
I'll
does AT&T have anything to do with the delay?
With the what?
With a delay in working out the
Yes,
agreement?
part of the delay was AT&T themselves,
Then
yes.
why are we paying,
Why-
we're rewarding them by paying them 8 to 10 times more than we should be?
I could, I can have the suggestion taken by Mr. Ufracio, pay a disputed amount and say that we will pay the AT&T rates, but I think I need to verify first. I think these numbers were already migrated over.
I think court has
They may have
approved that,
had-
but I'm not sure that the transfer has been made, in my opinion.
It may not have been made internally from DIR to AT&T, and that's what I need to look for. Because we have called AT&T and they don't show the transfer on some numbers. So it may be a bureaucratic gridlock between DIR and AT&T. But I certainly will have a report for you next Tuesday.
Next week, I run it by Mr. Guerra, because we want him to make sure that he's on top of what's going
Oh,
on.
yes, I heard your instructions, certainly.
All right.
Judge, it's also important for you to all to know that the budget office, IT office, purchasing, and human services and health department have gotten together and had a very structured meeting on how to get this resolved. And there was direction and responsibility taken by our IT department to try to get this thing resolved as soon as possible. So it's something that we have not ignored. We've been working on it diligently to get this resolved.
We have a motion and a second to approve the request for payment. Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item D is a similar situation, approving process payment of claim for telephone service of Verizon Southwest vendor number 251577 for Wesco Clinic. Account number is indicated on the agenda in the amount of $168.56 for the dates of service of March 28th through April 26th, 2013.
Judge, and on the previous, the approval was to pay the invoices amount as billed?
Yes,
All right.
$4,926.69.
Got it, thank you.
And we have a request to approve payment of that next claim under D as in David.
168.56, for 168.56, sir.
Is this a separate claim from AT&T?
This is from Verizon, sir. Through us
Do
in
we
the...
have the same problem?
Yeah, it's the
with it?
same problem, sir. Yes,
Well,
correct.
that needs to be addressed also.
Yeah, we ought to pay it, but address it.
Yes, sir.
We need to stop paying more than we should.
I agree, sir. And there's a lot of people working on this, but there's a large bureaucracy involved with AT&T and
All right, we have a
DIR.
motion and a second. Those in favor indicate by saying aye.
Aye.
Verizon
motion
does
carries.
have different set of circumstances. Verizon has no state or cooperative purchasing contracts. What I'm trying to get, and I've been working on this for 30 days now, is to get something from Verizon that shows that the areas in which they have the lines are exclusive to Verizon, just like there is for Magic Valley on certain
Marty,
areas of electricity.
any and all situations that the county's paying more than we should needs to be addressed.
Yeah,
In this case, it may end up being a proprietary exemption, and we may be.
Well, we'll find out what it is, Marty, so we don't
Well,
have to
I know
guess.
that's what it is on Verizon. I cannot get someone at Verizon to tell
All right,
me.
well, you said it
what-
may turn out to be implying
No.
that you were not
On
sure.
Verizon, no.
It's proprietary.
It's going to end up being a sole source. But I will tell you, I can't come to sole source forward to you
Marty,
until I
we've
can.
approved it already, and, but run all these claims by Balde for next week, put it on the agenda, and let's cover it.
Okay, but Judge, I will tell you that this arose when the decision was made that requisitions needed to be entered for purchase orders. These were all being paid direct.
Well,
I've
the
had a
issue
very
is
short
not
time in
the
which-
method of payment, the issue is the amount.
The amount was being paid,
Why are we
Judge.
paying more than
The
we should
amounts
be?
were being paid.
Yes. Judge,
Well, there was no
we're
question.
gonna work with Mr. Guerra and get this resolved, and Mr. Ramirez at IT, we'll work on it diligently together to get this resolved. And it's not only our department, it's a couple of other departments as well, but we'll get this resolved and report to court next week.
All right.
It's
Thank
true,
you.
this is a countywide issue, Judge, that needs to be addressed.
Yeah, it's a countywide issue.
Balde, it's,
Balde's gonna get on it.
Well, so does Renan. I mean, this is all,
well, he works under Balde, so.
all right, let's move on. Go ahead.
Item E, sir, requesting approval of claims invoice submitted by the University of Texas Health Science Center at San Antonio for preparing the 1115 waiver program plan in the amount of $20,000 with authority for the county treasurer to issue payment after reviewing and auditing procedures are completed by county auditor. Sir, this is the cost it cost to get our 1115 plan completed. I had brought it before court that we had an agreement set up with them for $100,000. However, when the plan was completed, there was an additional $20,000 because the plan was a lot more complicated than initially thought and proposed for. This is between the university and us, ourselves. Reviewed this with Steve Crane, and we need to follow through on getting this this claim paid.
Judge, I have a comment in reference, and I just wanted to repeat what Eddie said, that the county entered into a contract with this entity to provide the services for an amount not to exceed $100,000. And we already paid the $100,000 that the county committed to pay for the services, and the $20,000 in excess to whatever was agreed between the two parties.
What is it that changed?
Sir, what changed is the federal rules changed, and when the plan was being developed, additional requirements of work and additional requirements of time were added to the initial plan as indicated by the federal
But
government.
who authorized the addition of all that additional work?
That work, we have to submit it if we wanted to do 1115 at all, sir. I mean, that's the federal government asking us to expand the plan beyond the original scope.
What was the scope of the original 100,000? What work did they agree to do?
They wrote the entire plan, which encompasses all 1150 and all the just dish rep programs, all the uncompensated care programming. We're talking about a document that's well over 890 pages long.
Steve, can we, how do you see this transaction?
I think what we need to do is we need to have an amendment to the interlocal agreement done.
There'll be no action at this point.
And the amendment would then specify what they did over and above, and we agree to it.
Very good, sir.
Is there a time issue here?
Yes, sir, there is a time issue, but you know what, sir? We'll follow through on, I'll review with Steve in his office and review on
And
the...
let's do it right, and we'll do it next week. We'll amend the existing contract, authorizing the expenditure of this additional 20,000.
Yes, sir.
All right.
Thank you, sir.
Thank you, Eddie.
Thank you, Eddie. Item 11, emergency management.
11A, there's no report, Judge.
All right. You might call him up and ask him why front page said Donna is not going to have any water.
Yeah.
I'd like to hear a little bit about why.
I'll clarify that. He was not in today. He was not feeling well, sir. So I'll clarify
Call him up and
that.
ask him, see if he'll tell you, and you can report a little later.
Absolutely. Thank you, sir.
All right, number 12, IT Department. Is Mr. Ramirez here?
He is not, as Monica is telling me, but he is asking on behalf of the constables, he is asking to purchase new wireless devices through our membership participation contract, and that's DIR SDD 1779. That is our awarded vendor, Verizon Wireless. He's asking for a 4G unlimited mobile broadband plan at $37.99 at 20 data cards for the duration of the year, which would be 9 months, April to December, along with equipment costs at zero cost. Again, it's for office use constables, and there are some accessories at $19.49 times 20, which are the number of units he is, or devices he is asking for approval.
If pertains, so move.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries. Item 13.
Yes, Ms. Munoz did have another commitment, so for the HIDA Task Force, she is asking approval to process claims and invoices, again with authority for the county treasurer to issue the payment and check after review and auditing process procedures are completed by our county auditor. This is to McCurry Aviation Company, Inc. There are some invoice dates, October, November, December, and January of this year, and they are for each respectively $50.
There for what?
It's an invoice from McCurry Aviation. I would imagine that they weren't timely submitted, and there may have been an issue with respect to how they were
What were the
not submitted. So, I'm sorry? Right, okay, well, I wasn't trying, right, I wasn't trying to go into detail, but they are for seized aircrafts in relation to their operations.
Okay, I was wondering where
Right,
the plane was.
Right, again, it's because it's HIDA and the nature of their
Right.
business.
So move.
Need a second? Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you, Judge Commissioners.
Item 14, Urban County.
Good morning, Judge and Commissioners.
Morning, sir.
The Urban County Program, on behalf of Hidalgo County Precinct Number 4, is requesting approval and award a best and final negotiated contract with Osa Justice Inc. in the amount of $35,976, utilizing CDBG fiscal year 2012 street improvements funds.
So move.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item B is Urban County Program, on behalf of the City of San Juan, is requesting approval of a best and final negotiated contract with Cruz Hogan Consultants, Inc. in the amount of $22,430, utilizing year 25 funds for engineering and surveying services for water sewer improvements on Lincoln Avenue and alley between 11th and 12th Street in San Juan, Texas.
Move to approve.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you.
Tony, can you give Raul an update on the status of the environmental clearance?
On the what, Commissioner?
The environmental clearance of South Fork.
Yes, I will, sir.
Lisa Raul, tell him what the status is.
Okay.
All right.
You want me to meet with him after?
Yes.
Okay, thank you.
Next item, Elections Office.
Thank you, Judge. Thank you, Commissioners. Item 15A is approval of the appointment of members to the Hidalgo County Vote Centers Committee based on your recommendations from this court. And Karina is giving out the most recent list, and you can see in red the new members that were approached the committee during the visit from Lubbock County this past week. And you can see the 4 members that were there, Mario Garcia and Don Medina, and then Sylvia Cruz is a member from Mission CISD, and Joel Valdez was there at the meeting with Lubbock County. And then down below are city secretaries, Hilda Pedraza from PSJA, Annette Villarreal is from McAllen City, and Elizabeth Walker is from the city of Weslaco.
Move to approve.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Yes, sir.
I'm sorry, Judge Commissioners, I had talked to Mr. Mona, I had asked that Mr. Lauro Torres be a part of,
Let's put him on. I mean, we need to be inclusive.
Right, and Mr. Torres helps me out tremendously, and I had, can we
Why don't
include Mr. Lauro
need a
Torres from the
motion to
Executive
add
Office?
Mr. Lauro Flores to our committee.
Torres. Lauro Torres.
Torres.
From the Executive Office.
So move.
Definitely. Will you email me his information?
Yes.
Thank you.
Those in
That's
favor
correct.
indicate by saying aye. Aye, motion carries.
Yes, thank you, sir.
Torres is from where?
We do need to acknowledge the good work that you,
What department is it?
Executive Office, sir.
Executive Office, yes, sir.
want to acknowledge the good work that our elections office, through Ms. Ramon, did in their presentation on these voting centers. I think it was very professionally done and very informative, and we're very fortunate that we had two county commissioners and the elections administrator and her assistant come down at no expense to the county to educate us on these voting centers, and I hope that the community starts getting involved and appreciating the benefits of these voting centers.
Thank you very much, Judge. I appreciate that. And I would like to inform the court that we've already set up the next meeting. It is set for May 2nd at 6:30 at our warehouse, which is located at 317 North Klausner at the rear. And of course, you all are invited to come and join us and listen to our second committee meeting. We will be distributing all the maps and giving them the deadlines and our schedule, which of course I will be sending to each one of you. I just want to give you the second and third page, which is the schedule of elections that will be taking place this May 11th. You've got the schedule, which early voting will begin on Monday, May 29th. Election day will take place on May 11th, and the last page, just for your
I
information.
want to correct you. You said Monday, May 29th.
It will be on Saturday, May 11th will be election day. And
Early voting begins.
on Monday, April 29th.
Okay.
On Monday, April 29th, early voting will commence. The last page for your information are the elections that are taking place. We have got our full contract. We are running the city of Mercedes, Hidalgo ISD, and McAllen ISD, and we are leasing equipment to the city of Edinburgh, the city of La Jolla, and the city of McAllen. So for community members that are listening, please be aware of the elections that are taking place in your community and go out there and vote. It's very important that everyone cast their ballot and everyone be informed.
Thank you.
Thank you, sir.
Okay, our item 16, our Head Start program.
Good morning. We have several items. The first one is the end of the year activities. I want to call attention to those end of the year activities. The Commissioners Court, as the grantee board, is invited to any of them, and you have them listed there. We have the Parent Volunteer Appreciation, we have the Community Partnerships Appreciation, the Staff Graduation Celebration, then we have Center graduations for children. They have children's last day of school is the 22nd of May. Then we have appreciation of the staff, and then the field staff is the last day is the 24th. Then we have a holiday on Monday. But that is for your information, no action is needed. The next one is a recruitment report. And we do door-to-door recruiting. We spend 2 full days, and we make contact with 5,024 families. We have 3,690 positions to fill in terms of the children. Half of them are returning children, and so that's for your information also. Then we have the presentation of the nutrition contest winners. This is a contest to enlighten staff and promote healthy nutrition, and the winners are listed there for you. I'm going to quickly read through the list of first place winners that you have there, and you have the 2 classroom. We have Monte Alto as first place, Edinburgh 2 second, Donna 4 third place. 3 classroom centers, Edinburgh 1 first place, McAllen 6 second place, Hidalgo third place. 3 classroom centers, Progreso is first place, Vine Terrace is second place, Western Road is third. 4 classroom centers, Weslaco 2 is first place, Mission 1 is second, Weslaco 1 is third. 5 classroom centers, we have FAR is first place, La Jolla is second place, Alton third. 6 to 7 classroom centers, Las Milpas 1 first, Austin A1 second, and Alamo third. And the last but not least, the largest centers, 8 to 10 classrooms, Ed Couch is first, Mission 2 is second, and Edinburgh 5 is third. And that's also for information purposes only. The next we have is a discussion. This is for approval of the summer schedule, and you see the summer schedule that is being submitted. Policy Council has already voted on this and approved it, and we do have a 4-day week starting with the week of June the 3rd, and it goes through July. And on July the 22nd, we're back to the regular schedule. And so this does require your approval.
Move for approval.
Check.
Those in favor indicate by saying aye.
Aye.
Okay.
Go
The
ahead.
next, yes, the next item is discussion and approval to eliminate the perfect attendance incentive. We failed to list it as a specific area that we had determined needed to be eliminated based on our sequestration cuts of $2.73 million. I'm sorry, $1.73 million, and we did not specifically list it, but we are doing away with it for that reason. And then the other reason is that it was intended to help with attendance of teachers and assistant teachers in the classroom, and really we have more staff from out of the classroom than from the classroom that gets into the perfect attendance area. So we do need your approval in that one. We recommend that you approve.
So moved.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
The next item, there's no action to be taken. Under legal counsel's advice, we are pursuing some information, and we'll bring it back to you. Item G, discussion and approval for Hidalgo County Head Start Program to exercise option to extend an additional one-year term, the contract for services for air conditioning, plumbing, maintenance services with Roberto Ontiveros, DBA Junior Electric.
If everything's in place, so moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
The next item is to extend, option to extend for an additional year term the lease agreements for facilities under the same terms and conditions as before with the following private entities: Donna 4 Head Start Center, Edinburgh 3 Head Start Center, La Herencia Head Start Center, Las Milpas Head Start Center, I'm sorry, it's Las Milpas 1 Head Start Center, Mission 4 Head Start Center, Mercedes 2 Head Start Center, Mission 3 Head Start Center, McAllen 4 Head Start Center, and Westlaco 3 Head Start Center. Administration recommends approval.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And on the next, that's it. That's all we have. Thank you.
Thank you, ma'am.
Thank you. Yes.
Yeah, that was included.
Our right-of-way department? Valde, you want to handle it?
Oh, yes, Judge, I'm sorry. Mr. Peña is not with us yet. So for the right-of-way department, he is asking, or the office is asking authorization for your office, or specifically the county judge to sign the closing documents for FM 681, FM 2221 project, that would be parcel 31. This was approved by Commissioners Court on February 15th of this year, Judge.
Move for approval.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Judge, Commissioners, could we go back to item 11A, if we could, please? Mr. Oscar Montoya has joined us. He was at the doctor's office this morning, but he's come over to share his report with us.
Oscar, can you enlighten us as to what's going on in Donna?
Yes, sir, Judge, Commissioners. Sorry about being late. I was at the doctor's office this morning. Basically, it's the same report as I gave a couple weeks ago on that region. Donna's still not out of water. The city of Donna is not out of water. The issue was the push water, or avoiding using push water to save them money. During those meetings that I talked about where they were meeting at the TCQ, that was worked out, and that's basically what they're reporting. There was a transaction that took place between Engelman Gardens to go ahead and help get the water to the city of Donna because the Donna Irrigation District was out of water. Okay, that's the issue. Their allotments have run out, but the idea is to prolong the use of push water so that the cities don't use up too much money, and that's what was done here. They worked out a deal with the Engelman Water District, who does have a significant amount of water, so they should be okay. The last meeting we had, I know that the article said something about a month-to-month. They're doing it on a month-to-month basis because they don't want anybody to lose any money on the charges. But according to Engelman, they do have enough to carry Donna's city water for at least the rest of the year. So it shouldn't, again, the issue is we're still short of water. I mean, these kind of reports are going to keep coming out. And, basically we'll just have to stay on top of them and make sure that they don't, cause undue stress on the people. Bottom line is, we need to conserve water. We are short on it, but the good thing is that they're all working out on making sure that the cities continue to have water. The farmers, on the other hand, are starting to have some issues with irrigation. And hopefully I can give a report next week on what's going on.
But
with
as
some of
far
them.
as the citizens of Donna, they're going to have at least till the end of the year enough
Yes, sir.
water.
Barring any issue occurring between the deal that they have, Engelman has enough water to take care of Donna and North Alamo Water Supply. At least, they said no problem till November, probably the end of the year.
Okay.
So, and I'll continue to stay on top of it. Yes, sir.
Just keep it posted on.
Yes, sir, absolutely. We're also, again, I want to remind the court that we are still working on having a meeting on the 9th. We're trying to get all the cities, the mayors that I did talk to are real positive about it, and to try and, so hopefully that's the position that we want to take, that if there's any funds available, if the state or the feds make any funds available over the course of the next 2 years, that we as a county are prepared, like a region, as opposed to everybody going out for different funding, that we all go out and present one big funding for the county. And that's kind of our goal into having these meetings that we've been going to, and I'll keep you all abreast of that as well.
Thank you.
Yes, sir.
Thank you.
Next item, back, Bug.
Morning, Judge.
18, Precinct 1.
Morning, Judge, Commissioners.
Morning, sir.
Yes, we have an item on an amendment we had to do with the Mercedes interlocal agreement for the Mile 2 West project. At the request of the auditor's office, we made a change to make sure that we include in the interlocal agreement, aside from right-of-way acquisition and other services, that the city would also contribute to the road construction. So we made those changes. There seems to be, however, another concern by the auditors today, because the amount of the contribution from the city of Mercedes is not on the agreement. The city of Mercedes, on February 13th, took action based on information provided by the engineers, the project engineers, that they were responsible for 47% of the section inside the ETJ. Now, that amount was established to be $342,000, which the city did take action, and we have minutes from the city where they had the action. I was there at the meeting, and they approved $342,000. Now, we find something else today. On the interlocal agreement, it does say that if the project, which has already been let out, by the way, the project was let out by the state, and the successful or the low bid contractor is under by 15%, which is real good. Now, that means that the reimbursements to the county might be less, or should be less than the amount we already paid, which Mercedes is also included. So the amount of 342 might change, and it will change by the time we finish the project.
It should be
So
less.
just as an explanation, and we need to.
But that got nothing to do with the interlocal.
Right, well, the interlocal is to do all of that, and my recommendation is that all of the things that Raul just said to be reduced to the agreement, because the agreement is not very clear as to how that is going to be done. It says that the city will reimburse the county whatever TxDOT will not reimburse.
Right, exactly.
The county, but what amount?
Well, we don't know yet.
Right. So I think what we need to have in the agreement is the percentages you described, because I don't think those are there, Raul, yet.
That percentage may
Okay.
change, too.
I'm sorry?
That percentage could change.
It could change.
It could change, so, I mean, we need to move on it, and then, you know, if we gotta change it, we'll change it.
And the interlocal agreement, in my opinion, says that whatever TxDOT does not reimburse the county, the city will.
Yeah, but the interlocal agreement says that whatever TxDOT doesn't reimburse the county for construction, TxDOT is not going to reimburse the county for any construction. In fact, the county is going to give money to TxDOT, because TxDOT is going to do the construction, right, Raul?
Yes.
Okay.
But what the interlocal does say is whatever TxDOT does not reimburse the county for the construction, I believe it says, the city will reimburse. the
Right,
county.
exactly. That's on the,
All
But,
right, so we need to take action on
but
it?
that is my
Yes.
point, Steve, that the TxDOT is not going to reimburse the county for construction.
Well, if they don't, then the city pays for the entire bill.
right.
But the county is going to pay TxDOT for construction, and that's what the amount that the city is going to participate in.
We already paid the state
Right,
762,000.
right.
Not
But the
gonna
TxDOT
cost
is not going to reimburse
anymore,
you back
you
any.
could get reimbursed.
We should,
So
We should get him reimbursed for
Okay.
for everything, so,
if anything,
all right.
All right, need a motion?
Move for approval.
check.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you.
With the wording that he described, or not? In other words, are you approving any changes, Commissioner?
We
Do
approve
we
it.
need to make any changes? Steve?
From what Raul just explained, if there is any reimbursement by TxDOT, it reduces what the city has to reimburse. If there's no reimbursement by TxDOT, the city pays the entire amount.
Yes,
All right.
but the whole issue is that the TxDOT is not reimbursing the county. The
If
county
they
is
don't
paying.
reimburse the county, then the city pays the
city will.
tab.
No, but the county is paying TxDOT, so that the agreement needs to say that whatever the county is be responsible to pay to TxDOT for the portion of their city limits, they're going to cover, and it's not clear in the agreement.
What the agreement says is wherever TxDOT does not reimburse the county, the city pays for it.
Right.
Okay, Mr. Mingo,
Good morning, Judge,
Precinct
Commissioners.
Take the vote.
we did.
Mine is not that complicated as Precinct 1.
Let them go.
Hopefully, we can take care of it quickly. Item 19A, requesting approval to process the following invoices and claim with authority for the county treasurer to issue payment after review, audit, and processing procedures are completed by county auditor. We do have the PO there, Judge, 625224, and PO 625225.
Move for approval.
How come they're a claim, Mingo?
Sir?
What caused them to be claims?
I don't know, this should have never been here in Commissioner's Court because the supplementary was approved by Commissioner's Court, Ray.
No, that's what I'm saying. You got a purchase order, so.
Yes,
I don't understand why
I don't
it's a
know.
claim. Maybe
Well-
purchasing can explain it, I don't know.
yes.
But they were audited, right?
Yep.
Yeah, so there's nothing wrong.
It is my understanding from our contracts managers that the PO had, the supplemental, the work was done prior
Oh, okay, that's the issue.
to its
with it.
approval. Yes,
Okay.
that's why.
All right, do we have a motion and a
Move for
second?
approval. Yep.
Check.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you very
sir.
much.
Our budget office?
Morning, Judge Commissioner Sergio Cruz, Department of Budget Management. Item 20A, A1 is approval to accept the revised agreement for FM 493 from TxDOT and rescind the prior agreement. This revision will decrease the local participation from 10% to 1.2%.
Move for approval.
Check.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries. The effect of that is to rescind the other,
Yes, we'll be
The prior
rescinding the
agreement.
original agreement and
And
be
approve the
approving this
revised
revised
one.
agreement.
Okay.
Correct, sir. Item 28.2 is approval to submit to TxDOT a payment in the amount of $17,778 with authority for the county treasurer to issue payment and after review and auditing procedures have been completed by the county auditor's office.
Move for approval.
Check.
those in favor indicate by saying aye.
Aye.
Aye, motion carries.
On item 28.3, we're requesting approval of amendment to the interlocal agreement with the City of Donna for the FM 493 project. There is one correction. There will be a restatement on item 1. The county will be responsible for non-compensable utility relocations as opposed to compensable utility relocations. The compensable utilities will be coordinated by TxDOT. The county will do the non-compensable utilities, and Mr. Crane's office will be providing us with that document shortly. So we can have it approved subject to legal review on item 28.3.
Approval with.
And the change was not compensatable?
Yes, sir.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
On item 20B1, requesting approval of A, B, and C, which is authorize the approval of the clothing allowance for slot 0028 and slot 0052 in the amount of $500 each. This is for the sheriff's office. This includes approval of the interdepartmental transfer and the revised salary schedule. This is in accordance with Local Government Code, Section 152.071B.
Second.
Judge, this is a question for legal. This is the approval is to be effective on January 1st, 2013. The question is, can you legally approve retroactively a clothing allowance, Steve?
Are you on item 20A3?
B1A, approval to
20B1,
authorize clothing allowance effective.
To buy what?
Have there been any
Cash
transactions
allowance,
since then?
give them a clothing allowance, so they can buy a nice.
Theoretically, it should be today's date.
Today's date? Okay, so it's effective on today's date.
I mean, the sum is gonna be 500 no matter when.
Right, but what I'm saying is, you're not supposed to retroactively
Okay.
do something.
So it'll have to be effective today's date?
Yeah.
Right,
Yes.
Judge, but it's gonna be $500, but it'd be prorated starting with today till the end of the year, so it's not gonna be the entire $500.
Well, it doesn't say it's monthly, is that what it is?
That's what it is, it's a
No,
$500
it's,
for the year.
It's prorated by pay periods, $26 pay period. It is prorated.
Well, prorated for, what, 8 months?
Right, that's what I'm saying.
Correct.
It's $500 for the year, but effective.
The effect
starting
is
today.
still to give them $500.
Correct, that's correct, sir.
Correct.
These are individuals that were being placed in a special unit. The individuals that were removed from the unit have been removed the clothing allowance. This clothing allowance is particular to that assignment, so that's why we're having these individuals.
Clarification, includes A, B, and C.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries. Thank you.
Was that for A, B, and C?
Yes.
Yes.
Item 21.
Martha Salazar for the Purchasing Department. Nothing to report or action to be taken on item 21A1, 2, A, B, and C respectively. Item 3, let me just give you a report because I am going to be requesting no action on B or C as we are not ready to proceed until next Tuesday. The status of the negotiations have been completed. However, there is still formal review of the draft final agreements for both the depository bank and related services agreement and the lockbox and remittance agreements. So those not being finalized or approved through our legal counsel and the review of the tax office and the investment committee, we will be asking, that's the report, but we will be asking that this be placed on next week's agenda. I believe at that time we will be able to finalize this project.
So
So no action needed?
No action needed. On the report, I just wanted you to know what brought us to this point. We were hoping that we would have all the reviews by legal counsel and the committees
All right.
confirming that the terms, conditions, rates, and fees
Thank
are
you.
included.
Pursuant to 55107-1 and 072.
Thank you.
Entertain a motion to proceed to executive session.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries. It's 11:35.
Oh, I thought it was 12.
Back in an open session, Mr. Guerra.
Thank you, Judge, Commissioners. Item 23A under open session, no action. Real estate acquisition appropriation same. 23B pending under potential litigation, no action. Item 23C, Judge, Commissioners, I'd like settlement authority to make an offer of $1,896.74.
So moved.
Second.
Those in favor say aye.
Aye.
Aye, motion carries.
Item 23D, I'd like to have settlement authority to make an offer in the amount of $4,858.20.
So moved.
Second.
Those in favor say aye.
Aye.
Aye, motion carries.
Item 23E, I'd like settlement authority to make an offer in the amount of $750.
So moved.
Check.
Those in favor say aye.
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 Aye, motion carries.
Item 23F, I'd like settlement authority to make an offer in the amount of $720.
So moved.
Check.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And Judge Commissioners, just for the records, they were the claims of City of Palmview, Cristobal Vela, Patrick McNeely, and Joel Resendez respectively.
All right, before we adjourn, I want to announce that Governor Rick Perry, who had just been notified, has just ordered that all flags be flown at half-staff on Thursday, April the 25th, 2013, and should return to full staff on Friday, April 26, 2013, in honor of those who perished in the disaster in West Texas last week. I'm not sure, who do we communicate that to, Bob?
That would be with Daniel. Daniel is
Can you
former
make sure he
military,
gets
yes.
that?
I'll make sure he gets the message, and Daniel is former military, so he does know the protocol. Yes.
All right. Need a motion to adjourn?
So moved.
Second.
Those in favor indicate by saying aye. Aye. Aye, motion carries.
I don't know.